All right, we back with anonymous mortgages. This is 98 rights and liabilities of parties to anonymous mortgages. In the case of an anonymous mortgage, the rights and liabilities of the parties shall be determined by their contract as evidenced in the mortgage deed, and so far as such contract does not extend by local usage. 99 attachment of mortgage property rep by the Code of Civil Procedure 1908, 5 of 1908, CS 156 and V schedule. Charges 100 charges where immovable property of one person is by act of parties or operation of law made security for the payment of money to another, and the transaction does not amount to a mortgage, the latter person is said to have a charge on the property, and all the provisions herein before contained which apply to a simple mortgage shall, so far as may be, apply to such charge. Nothing in this section applied to the charge of a trustee on the trust property for expenses properly incurred in the execution of his trust, and save as otherwise expressly provided by any law for the time being enforced, no charge shall be enforced against any property in the hands of the person to whom such property has been transferred for consideration and without notice of the charge. 101. No mortgagor in case of subsequent encumbrance. Any mortgagee of or person having a charge upon immovable property or any transferee from such mortgagee or charge holder may purchase or otherwise acquire the right in the property of the mortgagor or owner, as the case may be, without thereby causing the mortgage or charge to be merged as between himself and any subsequent mortgagee of or person having a subsequent charge upon the same property, and no such subsequent mortgagee or charge holder shall be entitled to foreclose or sell such property without redeeming the property, mortgage, or charge, or otherwise then subject thereto. Notice and tender. It's 102. Service or tender on or to agent, where the person on or to whom any notice or tender is to be served or made under this chapter does not reside in the district in which the mortgage property or some part thereof is situate. Service or tender on or to an agent holding a general power of attorney from such person or otherwise duly authorized to accept such service or tender shall be deemed sufficient, where no person or agent on whom such notice should be served can be found or is known to the person required to serve the notice. The latter person may apply to any court in which a suit might be brought for redemption on the mortgage property, and such court shall direct in what manner such notice shall be served, and any notice served in compliance with such direction shall be deemed sufficient, provided that in the case of a notice required by section 83, in the case of deposit, the application shall be made to the court in which the deposit has been made, where no person or agent to whom such tender should be made can be found or is known to the person designed to make the tender. The latter person may deposit in any court in which a suit might be brought for redemption of the mortgage property the amount sought to be tendered, and such deposit shall have the effect of a tender of such amount. 103. Notice, etc., to or by person incompetent to contract, where under the provisions of this chapter a notice is to be served on or by, or a tender or deposit made or accepted or taken out of court by any person incompetent to contract, such notice may be served on or by, or tender or deposit made, accepted or taken by the legal curator of the property of such person, but where there is no such curator, and it is requisite or desirable in the interests of such person that a notice should be served or a tender or deposit made under the provisions of this chapter, application may be made to any court in which a suit might be brought for the redemption of the mortgage to appoint a guardian ad litem for the purpose of serving or receiving service of such notice, or making or accepting such tender, or making or taking out of court such deposit, and for the performance of all subsequential acts which could or ought to be done by such person if he were competent to contract the provisions of order 32 order 32 of the first schedule of the Code of Civil Procedure 1908, 5 of 1908, shall, so far as may be applied to such application and to the parties thereto and to the guardian appointed thereunder. 104, power to make rules. Power to make rules. The High Court may from time to time make rules consistent with this act for carrying out in itself and in the courts of civil judicature, subject to its superintendence, the provisions contained in this chapter. Whenever we come back, man, we're going to get to chapter 5, because I want to stay within that. Chapter 5 of leases of immovable property. Of leases of immovable property.